This is Top Story with Evans Mensah.
And Top Story is always brought to you by Bond, also brought to you by Gasem, Cement the Nation Builder, Vodafone, the future is exciting, ready, and nationwide. Now, defunct Capital Bank has filed a suit in court tonight, seeking to recover over 100 million cedis being debt owed by CDH Financial Holdings and CDH Savings and Loans, a bank which was among the two banks that were taken over by state-owned GCB Bank over severe liquidity challenges once the High Court to order the defendants to pay the amount plus accrued interest. Now, this is all happening on the day when it became obvious that the receivers who were appointed by the Bank of Ghana in the wake of the collapse of Capital Bank have filed a suit in court dragging the former board chairman Mensa Otabil, his church, ICGC, and a host of others who they describe as accomplices to court for alleged fraud. We'll have both cases for you shortly, but let's start with the suit filed in court by the receivers for Capital Bank in the wake of their collapse. And my colleague Raymond Akwa has the details of that. So let's be specific. Who took who to court in this case?
In this case, the people who have taken over Capital Bank as receivers, joint receivers, Vish Ashiabo and Eric Nananipa, they are all PricewaterhouseCoopers.
Okay.
They're the ones who went to court. What they have done is they have dragged 16 human beings and institutions to court.
Let's go to the list.
So the very first one is William Atuesian, who was founder and in charge of what they call it, Capital Bank. The second one is Mensa Anamwa Hotel, the pastor in this particular case and the general overseer of the ICGC.
You mean Mensa Anamwa Otabil?
Yes.
Okay.
Again, Ohineba Osei Akoto has also been with Capital Bank for some time. Stephen Enchil has been there right from the beginning of Capital Bank. Kingsley Ataganza, remember that you have been told William Atuesian worked in Zimbabwe. The gentleman he did most of his duties in Zimbabwe with is Kingsley Ataganza. Otabil and Associates.
Okay.
And let's get it clear. This is the company that the general overseer of the ICGC church set up himself.
Okay.
So that is the Otabil and Associates. The seventh defendant in this case is the church, International Central Gospel Church. And also, the eighth defendant is Kojo Ayisi Assuran. He is the board chairman of William Atuesian's ASIC Life Assurance.
Okay.
And John Kofi Mensah. John Kofi Mensah is currently the ADB boss. You do know that he was formerly, somewhere around 2013, 2014, with Capital Bank. And he resigned, wrote a long letter about what's been happening in the, what they call the bank for some time. Now, Edwin Obin Donko is a senior pastor in this particular case at the ICGC King's Temple in London.
I see.
He is also named as part of the people who ought to answer questions in this case. And we know Fitzgerald Donko. Fitzgerald Donko is a pastor. He was the head of the bank until the bank went into receivership. You know that he had denied that his signature was supposed to be on a document and back and forth. You read the voters' report.
Yep.
Amadou Montia is also be part of the bank's engagement. Kofi Kwakwa, what they call it, used to be on the board. Frances Edumante in 2014 left this particular Capital Bank board. And she's been very forceful about making that particular point. But she is on the list of people who have to be held accountable on this particular issue. And Isaac Osa-Mensah Thompson is also one of the people that have been held to court on this matter. So these are the key people. And of course, Isaac Osa-Mensah Thompson is with OTM, and that's known. So these are the key people, all 16 of them.
So the allegations before the court, as captured in the court documents,
yes.
What is it that the plaintiffs allege that these individuals did, for which reason they've dragged them to court? This is a civil case, by the way.
Yes, it is.
This is a case in which they are demanding that the list that you just went through should be made to cough up X amount. And we'll go to the specifics shortly.
Yeah.
Let's go to the specifics.
So let's separate the team into two groups. One, the first person, William, the third person, the 10th and the 16th person are all deemed to be at all material times shareholders of the plaintiff's company. This is what they call it, the Capital Bank. So it makes reference to 4 shareholders.
Okay.
And the rest of the people, what they call it, are directors of the company with which the William Atuesian was a member, and also Dr. Mensa was about, as stated there, as the second defendant, as chairman of the board of directors. So it separates the two groups and deals with them as such. It says the over the period of several years, those who are deemed to be specifically directors actually approved in their capacity as directors several loans and credit facilities to other companies and made placements of funds to other companies. The plaintiff says that the said directors approved loans and placement of funds to themselves and related parties without the requisite collaterals and in clear breach of the company's internal policies and relevant banking and Ghanaian company laws.
In other words, they knowingly breached the banking regulations in giving these loans. Allegedly.
Yes. It now takes on the people involved and proceeds by making this claim too. It says the defendants, all of them put together, were engaged in a scheme of fraud on 1, its customers, 2, regulators, 3, the public.
Fraud.
And it gives the particulars of the fraud. It says that 1, the defendants all put together approved the purchase of commercial paper from related companies without recourse to internal policies and or banking regulations. The instruments described by the defendants as commercial paper were in fact, and to their knowledge, not qualified as such, and a scheme to siphon funds unlawfully out of Capital Bank.
These are serious allegations.
Very good. And it proceeds to say that there are several commercial papers which were purportedly purchased on behalf of the company itself, that's the Capital Bank, but the 12 defendants, in this case, Fitzgerald Odonko, denied executing those instruments and claimed that his signature had been forged to give authenticity to the purported papers in this particular case.
And because we've been sort of dealing with this quite in some comprehensive manner, I recall this particular incident in the Boulders report.
Yes.
And Fitzgerald Odonko sent a mail, you recall, and the mail was reproduced in the Boulders report to Mensa Otabel, complaining that he's seen that business dealings and monies had been
sent to other groupings in the way of commercial papers in his name,
and that he did not authorize it, and that if there's the signatures on the thing being approving those deals, he didn't approve it. What we didn't see in the Boulders report is whether or not Mensa Otabel, who was then the chairman, replied to that.
Yes, that's true.
Now it's become a subject of a court action.
Yes. Now, it also mentions that a huge amount of money, which is part of the liquidity support. And don't forget, we had a long-running discussion over 620 million liquidity support.
620 million that the Bank of Ghana gave to the bank when they realized that the bank was in trouble. Liquidity support gives to a bank is given to a bank in those circumstances so you can stay afloat.
Yes.
You can, sort of serve your customers.
So the report is saying that a huge amount of the money was given to the first defendant, in this case, Mr. William Atuesian.
Okay.
In this particular case, for business promotion, without any effort at seeking an account of how the bank's fund had been set.
Let's be specific. That amount in the Boulders report, I think, amounted to 25.7 million cedis.
Yes. Yeah.
That's for the business promotion. And in that Boulders report, it also claims that that amount, the business promotion, was disbursed with the authorization of only the chair, as in Mensa Otabel, and against advice from the management,
including
who claimed
the very gentleman Fitzgerald Odonko in this particular case. Yeah. Yes. Now, the defendants also approved several loans worth approximately 126 million to themselves and their related parties without requisite collateral or security. Basically, no collateral was demanded, not the right ones to make sure that they, within their groupings of directors and shareholders, received money without having to go through the right process. Now, there's an interesting development that you should be interested in on this one. Now, the joint receivers are saying that the records show that as a direct result of the misgovernance of the,
individuals you mentioned earlier.
Very good. All of them. And the willful breaches of banking regulations asserted to 1st December 2015, the plaintiff had a cumulative amount of, that's Capital Bank, had a cumulative amount of approximately 482 million as impaired and or non-existent investments, which amount included 52.3 million misrepresented to the Bank of Ghana as required capital for the grant of requisite banking license.
That we didn't know before. This is fresh information.
So that was also another information that they are providing. Now, they proceed to say that the defendant therefore sought approval from the Bank of Ghana for the 482 million non-existent investment to be converted into a loan to be paid by the shareholders and supported same with the shareholders' resolution to the effect. Now, let's keep the two together this way. The joint receivers are saying that the defendants have failed and or refused to make payment of the said shareholder loan as of August 14, 2017, when the plaintiff was placed under receivership. An amount of 748,251,000 in this case is the remaining outstanding unpaid by the people all put together.
That's a huge figure. That's just a little over 200 million shy of a billion cedis.
Yes, and it breaks it down into the amounts in this case. So the first defendant in the case of William Atuesian is to pay some 468 million. The second defendant in the capacity as Otabel and Associates is to pay some 51 million. Now, the third individual that matters in this case, that's the third defendant, that's Ohineba Osei Akoto, is to pay some 36,664,000. The fourth defendant, Stephen Enchil, is to pay some amount to the tune of 73 million in this case. Now, again, Kingsley Atagansa, who is the fifth defendant in this case, is to pay some 36 million. And the eighth defendant, Kwajo Aisi Ahren, is to pay some 44 million specifically. 15 million is to be paid by John Kofi Mensah, who is the 10th defendant. The 11th defendant is paying some 14 million. And the 16th,
who's the 11th defendant?
The 11th defendant in this case is the Edwin Obendonko, the senior pastor, who is in charge of the ICGC King's Temple in London.
Ah, okay.
Is to pay the amount in this case being, yes, specifically the 14 million. And the very last person.
So the allegation is that he also took monies that had not been paid
to
the bank. Okay.
And Isaac Osafamse Mensah is also to pay an amount of 24 million. That is why they are being dragged.
But did it tell us? Because they mentioned the ICGC, the church itself.
Yes.
Did the church also take loans that they have not been paid?
That's what I actually mentioned in the 7 defendants.
Okay.
The 7 defendants being the International
Central Gospel Church. Okay.
Specifically, is to pay some 51,629,319. 51 million. Okay. 629,319.
That's what the church needs to pay.
Yes.
Okay. Raymond, thank you very much. But in the last couple of hours, we've also become aware that apparently Capital Bank itself has also filed their own suit, and this is their fight back, directed at CDH and Joseph Hastad. Joseph.
And so this is directed at CDH Financial Holdings Limited and CDH Savings and Loans Company Limited.
Okay.
Now, more details on this is creating a situation where now we are finding out that apparently this suit is being filed in the name of Capital Bank Limited, care of PricewaterhouseCoopers Ghana Limited.
Okay.
And they are suing per Vish Ashiagbo and Eric Nipa in their capacity as the joint receivers.
I see. So the joint receivers are being sued.
No, in this case,
let's clarify.
The joint receivers are suing
in the name of
the defunct Capital
Bank. Okay.
And they are suing CDH Savings and Loans and CDH Holdings. Let me run you through the statement of claim. It says the plaintiff, in this case, Capital Bank, the defunct Capital Bank, the statement of claim says, is a Ghanaian registered bank which is currently under receivership pursuant to the Bank of Ghana Act. And it goes on to say that the defendants, that's the CDH folks, are related financial service firms which are licensed as such by the Bank of Ghana and the bookwork in the country, the statement of claim says. And it goes on to say the plaintiffs, in this case the defunct Capital Bank, say that the erstwhile Capital Bank invested with the defendants various sums of money, being monies in both Ghana cedis and also in dollars, and that the said investments have variously matured since July 20, 2017, with the latest maturing on February 2, 2018. And that the plaintiffs are saying, that's in the defunct Capital Bank is saying, that after several meetings with the defendants, the parties undertook a reconciliation of all the transactions between themselves and settled the records and agreed that the defendants were to pay all outstanding amounts owed the plaintiff. And the plaintiff is saying that as at 31st December 2017, the defendant owed an amount of 83,849,123 Ghana cedis. That's the amount in cedis. And then there's another amount in US dollars, which is $5.289 million US dollars. That's also owed. And so they go on to give additional details that the plaintiffs are saying that the defendants duly acknowledge the indebtedness, but all its efforts to recover the money to date have actually proved futile. And so the plaintiff is saying that despite several promises by the defendant to make the necessary payments, the CDH group have refused to do so despite the several demands. And the plaintiffs say that the inability of the defendants to make the payment on placements and other investments made with them poses a great risk to the investing public, as it may be an indicator of the insolvency of the business of the defendant.
I see.
The CDH Savings and Loans and the other firm. And so they go on to make specific demands. And let me run you through that briefly. They are asking for an order directed at CDH Savings and Loans and CDH Investments to jointly and severally recover the amount in question, the 83 million series and the 5 million series, the $5 million. They're also asking for interest on both amounts running up until the 31st December 2017. They're also asking for damages for breach of contract and also asking for cost. And finally, they're asking for an order directed at the governor of the Bank of Ghana to withdraw the license of the defendants, that's CDH Savings and Loans and CDH Investment, for their inability to pay back investments on maturity date. And then they're asking for any other reliefs that the court may deem fit. And this is actually a document that's been signed on behalf of Capital Bank by Joe Debra, the lawyer who is representing them, through the folks.
And Joe Debra is a renowned financial lawyer, and very adept. He knows what he's doing in this case. Let's thank you very much, gentlemen. Let's quickly speak to. We'll be speaking shortly to legal practitioner Yao Pong, who will join us on the line very shortly as we navigate, try and break some of the issues down for you to understand legally. But let's speak to banking consultant Richmond Ituahene, who joins us on the line right now. Mr. Ituahene, thank you for your time here on Top Story. You have called in the past for some action, some legal action to be taken. This is a civil suit. What's your reaction to the steps taken by the receiver?
I think it's a step in the right direction. And I believe, as we heard from your analysis, there is an element of fraud, which I believe it's to just have to be dealt with in the criminal side of the issue. So I believe it's in the step in the right direction. And I think the receivers have done very well. And all those who are, as I've always been saying, all those who are found culpable must be able to return all the monies to where it belongs. And I think it's in the step of the right direction.
But conspicuously missing in the list of people being sued is the officials from the Bank of Ghana who approve some of these dealings. And we know that in some cases such as the Capital Bank, when the liquidity support came, the Bank of Ghana sort of gave them, a leeway to spend the money, some may say anyhow, and we've read the documents. And yet, in the action that has been taken, there's no mention of any complicity on the part of Bank of Ghana officials who make these approvals. What's your reaction to that?
Yeah, last week, if you happen to be at your forum, the financial forum, I think the governor was very explicit about that. And I believe, from what I heard her saying, they have done the investigation, and shortly, I believe, those who are found culpable within Bank of Ghana would also have their names be published, and they will be referred. Because I think theirs will be more of a criminal. They will be more of criminals, so they will be taken it from the YOCO to the Attorney General office. I believe they will be dealt with as is being done at the moment. Because, I even heard a man's name there who had happened to be a Bank of Ghana former director. You mentioned his name. I think you forgot to mention his name. And I was wondering how he could preside over all these things when he was part of the board members. And it's unbelievable. I heard it, and yes, this morning when I saw it from your Daniel, I couldn't believe what I was hearing. But this is all that I have been saying. People who are found culpable, who are supposed to be responsible, go and mess up people's deposit. So what the receiver is doing, it is a step in the right direction. But I would also say that, in as much as he's doing the recovery from civil, they should quickly get to the criminal aspect of it. Because if we treat that one and we leave this one, because I heard your analysis. I don't know, I'm not a lawyer, but you said fraud. I heard fraud. Fraud is a criminal issue. And so if we're dealing with recovery, now we must look at it from the criminal aspect, so that all those found culpable, including the Bank of Ghana, that you are worried. We are worried. I'm worried. I am worried because I believe all these things went under the nose of certain people in responsible position in Bank of Ghana, and they must be dealt as such. As I've always been saying, they must be brought to book, and where they are found culpable, they must be dealt ruthlessly, because they should have known better. They should have even known better than the shareholders and the directors.
Yeah. Let me bring in, just stay on the line for me briefly, Mr. Chohan. Let me bring in lawyer Yao Pon, private legal practitioner. Mr. Pon, thank you very much for your time here on Top Story. I want to clear this up for me. We were hearing that the Capital Bank has sued, and of course, the Visha Shagbo and Regnadi are suing in the name of Capital Bank. But Capital Bank is defunct. I mean, legally, can a defunct entity sue anybody?
Thank you very much. I'm afraid I may not be able to give you a direct answer, not because I don't know, but I think that once the suit has been filed, and I've just been favored with a copy of the writ, and it confirms what you have stated right now, and I think it will not be proper on my part to answer the question directly, because it could be a likely issue that may be raised by maybe whoever will be acting for the defendants. But maybe if we were to talk about how a company comes into being and how it ceases to exist, generally, then we can talk about that. So if you may forgive me not to answer this question directly.
Broadly, yes.
Yeah, well, I mean, we all know that for an entity to become a company, I mean, you have to comply with the relevant provisions of the Companies Act at 179, and that will include filing the appropriate forms and also then being issued with the appropriate certificates of incorporation and maybe to commence business. And in the case of a financial institution like the banks, I understand that before the certificate to commence business is issued, the Bank of Ghana will have to issue you with the appropriate license in accordance with law. And 930 has spelled out copiously the steps to be taken by both the person applying for the license and the Bank of Ghana itself, including a thorough investigation about the directors and shareholders and all the entities that will be involved in the operations of the bank. And so when that is done, then it comes into being. The question is whether or not when the Bank of Ghana revokes the license of that company that has become a bank or that has commenced the engagement in a banking business will become defunct in the sense of insolvent. And if it becomes so, the question is, does it cease to exist? That is persona or personal, the capacity as a person or legal person, does it lose that persona when the license to engage in banking business is revoked? I think that is an emerging question, and I will leave that to the lawyers who may be employed or by the defendants themselves. But except to say that we know how a company becomes liquidated and therefore ceases to exist, and therefore when it ceases to exist, then it may not be able to perform the functions of a living company. And that is still emerging. So if I may just leave it.
Yes, and also very quickly, and another quick point of law that I need to quickly explain for me. I see in the suit that has been filed against the Capital Bank, Mainsal Tabal and others, there's a mention there of fraud, but this is a civil action. I mean, but fraud, for my little understanding of what it says, is more criminal than anything else.
Well, but there are set of facts on which criminal proceedings may be founded, and at the same time, civil proceedings may be founded. But we know as lawyers that when fraud is pleaded in a civil matter, the standard is the proof beyond reasonable doubt, which is the same standard in a criminal matter.
No.
But that in the civil court, it may not end in any criminal sanctions, usually. But then after that, you may have to then bring a separate action in criminal proceedings, because that is only the exclusive authority of the Attorney General, who alone determines finally whether a person's conduct is criminal in nature or is prescribed by any law, which is in the nature of a criminal offense.
So
that even when the court determines that in a civil matter, there is the Attorney General that will finally decide whether prosecution in the criminal proceedings should also commence against that person.
Okay. I'm grateful that you joined us with that explanation. A final question to you, Mr. Chiahene. One of the names sued today, individual sued, is John Kofi Mensah. Dr. John Kofi Mensah last year was appointed by the president to head ADB. The fit and proper, question emerges. Is that a legitimate concern to raise at this point?
If you remember, at one of the shows in the news file, I raised this objection that, you see, when you are under investigation, something has happened under your nose. You cannot pass the proper faith test. There is no way. Because if you go through, I've gone through recently I was doing a lecture on it. I've gone through line by line, the probity, the soundness, all those things are spelled out. So I was wondering how he found himself in other institutions. So I believe, as it has come to light, those who passed him the test may have to reverse the entry so that he come out of it and face the full rigors of the law. Because I don't think the proper due diligence was done at all. In the haste of appointing people, we tend to flout the fit and proper test. And the fit and proper test regime is something that determines the character and the caliber and the person with integrity to manage institutions. So for me, if I was in his position, possibly I have to resign, because this thing, other than that, Bank of Ghana will have a case to answer because he hasn't passed it at all. Because at the time he went there, this case was still under investigation. So whoever appointed him possibly didn't do his homework very well. So I think now that it has come to known, those who appointed him must be thinking right. So either they withdraw him, because other than that, it will make a mockery of all that governance and the proper faith test and whatever we've talking. It will make mockery of it. So I hope they will learn from it. In future, they should take their time and do their proper investigation before people are appointed to positions. Other than that, we will defeat the whole corporate governance issues that we're talking about.
That's banking consultant Richmond Tuahene there. And if you join us around 6:30, we're also getting a reaction from CDH, Financial Holdings. They've been sued also. They have a response, the allegations leveled against them. We'll bring those details to you. Newsnight starts right now.